So the Supreme Court of the United States just issued a unanimous decision upholding your right to privacy in your home. This isn't that surprising, except that it was unanimous and it involved firearms. Yeah, you heard me right. The conservative justices and liberal justices came together and upheld rights in the Supreme Court, something that we haven't really seen enough of in recent times and is shocking, particularly in light of the political climate surrounding the court and the political climate surrounding firearms. We're going to discuss this using an article written by Stephen Gutowski, who is an excellent writer on firearm issues and particularly Second Amendment issues. He's associated with the Washington Free Beacon, but we're going to use this article from The Reload, which is a firearm website that he founded. And we're also going to take a brief look at part of the opinion that came out of the Supreme Court. So stick with me and watch through to the end so you get all of the information. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, and I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, make sure you hit that like button, hit the subscribe button, hit the notification bell, and don't miss any videos that come out so you know what's going on in the world, especially in the world regarding the legal issues of the day. All right. So here we go. We're going to first go to this article from The Reload. Again, this article and the Supreme Court opinion are going to be linked down below in the description for you to take a peek at. I want to make sure and give tons of credit to Stephen Gutowski. He's been on this show before, and he is a phenomenal writer, and he's always on top of Second Amendment issues. So if you like that type of stuff, make sure you go to his website here, and I'll link his Twitter account too, and you can follow him there as well. So you're always keeping up with what's going on in the Second Amendment. Okay, so the Supreme Court strikes down warrantless gun seizure. They unanimously ruled on Monday that police violated the Fourth Amendment when they entered a Rhode Island man's home and seized his guns without a warrant. We're going to take a jump in just a second to the Supreme Court opinion because it lays out the basic situation. So rather than have me summarize it, I'll have Justice Thomas do it so it's complete. But the court ruled police in Cranston, Rhode Island violated Edward Caniglia's rights when they took his guns and ammunition in 2015 after an argument with his wife caused her to become concerned about his mental health. Caniglia was taken for a psychiatric evaluation, but not held after telling his wife to shoot him to end their fighting. So they're in the middle of a fight. He says, just shoot me and put me down. She gets concerned for his safety. He agrees to go to psychiatric evaluation. They don't hold him. He comes back, his guns are gone. He claimed in court he only agreed to do the evaluation if the police did not seize his guns, but police entered his home and took them away despite not having a warrant to do so. Let's take a peek at how the Supreme Court lays this out for completeness, because it's always important to remember that this is how the Supreme Court is making their decision. It's this set of facts summarized here and then extrapolated on later, but really this set of facts is what's informing their decision. Overall, it's a pretty short opinion, and it didn't need to be a long opinion because this should have been obvious to the First Circuit Court of Appeals. However, that court was trying to expand a community caretaking function of the police force, which isn't actually a function of the police force except in the minds of courts, but they're trying to expand this thing, and we'll talk about that and what it looks like and what that expansion means and why we should be on guard against this stuff. All right, so here's the facts from the Supreme Court. During an argument with his wife, petitioner Edward Caniglia placed a handgun on the dining room table and asked his wife to shoot him and get it over with. You can, not to make this a laughing matter, but it kind of is. You can imagine you're in a heated argument with your significant other. They're just tearing your head off. And it's like, all right, here, just put me down. Just put me out of my misery. I got it. I screwed up, okay? Like that, you can kind of get the idea for it. But instead, she leaves the home and spends the night at a hotel. So, jokes aside, this seems to be they had a pretty big drag out fight, and sometimes in a marriage that happens, and that's what's going on here. So she actually takes a night to go cool off. The next morning, she's unable to reach her husband by phone, so she calls the police to request a welfare check. The responding officers accompanied the wife to the home, where they encountered Caniglia on the porch. The officers called an ambulance based on the belief that he posed a risk to himself or others. He agreed to go to the hospital for a psychiatric evaluation on the condition that the officers not confiscate his firearms. But once Caniglia left, the officers located and seized his weapons. So he's saying, you can't take my guns just because I'm going to the hospital. Now, had the hospital found some sort of issue with him, and they had to hold him there, there could have been a court order pursued. This was before red flag laws existed in Rhode Island, so they couldn't get a red flag protective order law or a red flag protective order for this guy to go in and take his guns. But there are other ways they already existed prior to red flag laws that would allow a court to say this person is a danger. We need to have a protective order, and that protective order includes the removal of any firearms from the home. But it's important to note that that's not what happened here. That is a possibility, but that's not what happened. He was not actually held. All right, so Caniglia sued, claiming that the officers had entered his home and seized him and his firearms without a warrant in violation of the Fourth Amendment. District Court granted summary judgment to the officers. The First Circuit affirmed that, extrapolating from the court's decision in Katie versus Dombrowski, a theory that the officers' removal of Caniglia and his firearms from his home was justified by a community caretaking exception to the warrant requirement. So the whole thing here is the wife calls for a wellness check, not for a restraining order, not for a domestic violence issue, not for anything like that. She says, I'm concerned. I can't get a hold of my husband. I want to make sure he's okay. So she calls the police. They go there, and then they end up seizing him. And they take him. They take him to the hospital, and they take his guns. And that's something that they didn't have any reason to do. He could voluntarily accompany them, but I'm guessing they used his seizure as the basis for taking the guns, because if he just went to the hospital, the police have no grounds to enter the home and take the guns. So that's what's going on here. And this is where this comes from, and this is why it's important. Neither the holding nor the logic of Katie, that's Katie versus Dombrowski, which is the case that they were citing earlier, justifies such warrantless searches and seizures in the home. Katie held that a warrantless search of an impounded vehicle for an unsecured firearm did not violate the Fourth Amendment. In reaching this conclusion, the court noted that the officers who patrol the public highways are often called to discharge non-criminal community caretaking functions, such as responding to disabled vehicles or investigating accidents. But searches of vehicles and homes are constitutionally different, as the Katie opinion repeatedly stressed. The very core of the Fourth Amendment's guarantee is the right. And this is actually a pretty big distinction. You have a right to be secure in your car, but that right is very, very limited by your use of public roads. And the public roads and the fact that your car has wheels and is movable, quite simply, is it's an almost automatic exemption to the warrant requirement so long as an officer has probable cause. That's why they're able to effect searches of vehicles on the side of the road for routine stops very frequently, because once they make a traffic stop for one thing, but then develop a probable cause analysis where they say, I have probable cause to believe that further criminal activity and evidence thereof is happening inside this vehicle, they get an exception to the warrant requirement because it's a vehicle. Similarly, when they impound a vehicle in an impound lot, they have the ability to search for an unsecured firearm, because what they don't want is someone robbing the impound lot, finding an unsecured firearm in a vehicle, and then going and using it to shoot people. That would be bad. Right? That would be a terrible thing. So they go ahead and do these searches all the time. It's a noted exception to the Fourth Amendment. That has never extended into the home. And if you want a great example of this, if you've ever watched Breaking Bad, there's this scene where Walter White is inside a mobile home at a place, and he's gathering some stuff, and the cop, I think he's his brother-in-law or whatever, the cop comes up and is trying to search in the vehicle, and the guy who owns the mobile home, has a really good Fourth Amendment argument with the police officer saying you can't enter there. You don't have a warrant to get in. The cop's like, no, I do, because there's wheels on this thing. It's got a vehicle exception. He's like, nah, that thing's been parked there for years. It's a domicile. You don't have the right to go in. It's a great scene, and it's actually very, very good application of Fourth Amendment law and popular culture, which is really, really rare to see. So I want to make sure and drive people to that particular thing. It's also something a lot of people might recognize. But the difference between searching a vehicle and searching a home is key. Oh, and I forgot to read the last part. The very core of the Fourth Amendment's guarantee is the right of a person to retreat into his or her home and there be free from unreasonable government intrusion. A recognition of the existence of community caretaking tasks like rendering aid to motorists and disabled vehicles is not an open-ended license to perform them anywhere. And this is really highlighting the danger that the court poses to the people when they illustrate any sort of thing. Like, the community caretaking exception is just acknowledging, like, sometimes a cop gets a cat out of a tree. Well, I got a cat out of a tree. Let's take this cat to your house, and now I'm going to search it for drugs. No. That's not how that works. That's not how we want it to work. That's not anything. And that's what the courts were attempting to do, and the Supreme Court went ahead and shut that down. And that is a good thing, and we should recognize it. And not only did they shut it down, it was unanimous. The First Circuit Court here was way out of line. But that's what guns are doing to courts. And that's why we really, really need the Supreme Court to step up and to go ahead and take on some Second Amendment cases and clarify how much right we have. Because right now the courts are trying to curtail it at every turn. Finally, this does not apply in any way to red flag protection orders or red flag laws passed by several states. This predates the passage of red flag in Rhode Island. But the fact scenario here is extremely similar to what a red flag protection order fact scenario would look like. So it's an indication that those red flag protective orders may not uphold under constitutional scrutiny. Is this a warrant? Is this warrant justified by probable cause? That's what you used to need to remove firearms or anything from somebody, especially in their home. It's not just a red flag order justifying an exemption to the warrant request. Why is it justifying an exemption? Because there is no information under a general red flag protection order that criminal activity involving guns is happening, or that they're likely to find evidence of that criminal activity and the firearm themselves inside the house. That's not what a red flag protection order does. A red flag protection order says this person may be a danger to themselves or others. We better remove their guns just in case. No. This is not how the warrant requirement of the First Amendment works. Fourth Amendment, warrant requirement of the Fourth Amendment. Come on, speak. This is not how the Fourth Amendment warrant requirement works. It is not to be just ignored if we think something might happen at some point. Probable cause is a long-established set of standards that need to be met with the totality of the circumstances, and that probable cause must be grounded in criminal activity, not in scared feelings or something like that. And that's where these red flag protection orders may come into conflict with that type of stuff in the future. I'm sure we'll be talking about this a lot more as these things become more and more involved in public life and as they start hitting courts for constitutional challenges. Until then, thanks for watching. Make sure you drop a comment down below and tell me what you think about this issue, about the Supreme Court. I, for one, was pleasantly surprised by how the justices handled this one, because during some of the questioning, there was some indications that maybe some justices might be okay with this, and turns out none of them were, which is great news. All right, thanks for watching, guys. Catch you next time. Peace.